right, I think we're running. Welcome everyone to our IP Experts Live webinar today on the topic Draft EU SEP Regulation. Before we get started, just two administrative comments. First of all, this webinar will be recorded, so everybody please be aware of that. Second of all, you will find in your webinar tools a icon for questions. So if you have any questions during our session today, please feel free to type them there. And if we have time in the end, we're happy to discuss them. My name is Jan Bösing. I'm an attorney at law, partner here at Bardele Pagenberg, and I am here today with my partner, Tilman Müller-Stoy.
Hi, nice to see you all.
And as I said, our topic today, the Draft EU SEP Regulation. It is, I think, Tilman, the hot SEP topic right now. It's everywhere. It's just being discussed almost controversially, almost emotionally sometimes. Today, from our perspective, I think we're trying to stay objective. We will take and consider both perspectives. Maybe I will take more the perspective of the implementer, and you maybe take the role of the SEP owner in case.
Yes, I mean, the points we're making are going to be the objective ones. Having said that, I think it's much more fun if we do it in a controversial way. So at least I am going to be emotional and very one-sided. Having said that, both of us are in real life neutral. That's important to note.
Yes, absolutely, because yeah, we see both sides, we represent both sides, so please always take this into account when we share our views here today. With that said, let's jump into our presentation today. And first of all, Tilman, maybe we can give our audience a little bit of background. Where does this SEP regulation come from? So maybe you can give us a little bit of a background. What was the situation and where is the Commission coming from?
Sure, happy to do that, and we'll keep that very short because everybody knows that. But it is important to understand what is going to be achieved or what is intended to be achieved, and to which extent that is relevant in real life and practice. So starting off, I think that's a point everyone can agree. SEP, the SEP environment, negotiation as well as litigation is complex. The litigation costs in the SEP area are high. In continental Europe, as well as in the UK, as well as in the United States and other jurisdictions. What the Commission observed in addition was that there allegedly is a certain lack of transparency and efficiency when it comes to SEP licensing, at least with respect to some standards. And at least with respect to some potential users, licensees, when it comes to standard essential patents. Front and center are the SMEs, the small medium enterprises. And one can draw that from the impact assessment report, which was provided together with the draft regulation. Another topic is that FRAND royalties are unpredictable. We'll comment on that later, whether they really are that. The whole exercise seems to be a preemptive exercise. So the complexity of the environment from the point of view of the Commission is acceptable, has been acceptable in the past, but could no longer be acceptable when it comes to IoT and when it comes to SMEs, simply not having the funds, so to say, to do a proper negotiation and to defend in litigation in case that negotiations fail. Also on that, we're going to provide some observations from practice. And then the last point, which is clearly not a point, is that there was no ADR dispute resolution forum. That's simply incorrect. And we'll come to that. Now taking those observations into account, Jan, what do you think are the the objectives that were communicated by the Commission?
Yes, I think it's very clear when you look at the observations, sort of the problems that the Commission considered being there in practice, that the objectives are to solve these problems. And they are trying to achieve that mainly through improved transparency with regard to number of SEPs, ownership, royalties. So particularly the question which declared patents are actually essential. I think that's a very key aspect here. Ultimately, of course, to avoid litigation, to facilitate negotiation, to try to bring the often conflicting sides together even before it gets to litigation, and ultimately also reduce transaction cost. Whether this is actually achieved may be doubtful, but we'll get to that also in a minute. Before we go into the details, we would like to know from you, from our audience today, from our attendees, the sort of the buzzword in the Commission regulation is dysfunctionality of the licensing market regarding SEPs. And we would like to know from you, before we share our view, do you think the SEP licensing market is dysfunctional? And you should now see a pop-up with this question. It's an easy question, yes or no. And please share your view. It's confidential. We won't see who answered what. But we, of course, were very interested in your view. And results are triggering in. So maybe we'll give you a couple of more seconds. All right, I think
that's more than an absolute majority. That's not bad. Finding that the SEP licensing market is dysfunctional. I think that's something I can agree with. Question is, will it become better?
Yeah, so in total numbers, almost 70% think of our attendees today think that the SEP licensing market is dysfunctional.
Having said that, the sample size isn't great, a bit better than the one in the impact assessment report. And here we had 40 voices.
Right. So Tilman, now to our view, and maybe you can start. What do you think? Is it dysfunctional or is it not?
Given my role today, I of course think it's not at all dysfunctional, but I can prove that with a few comments. So in my practice, I'm counseling behind the scenes, but also as front lead negotiator, more than 10 SMEs in SEP licensing negotiations, especially in the IoT space, but also in other spaces. In none of these cases, litigation has yet occurred. Some have already settled, so the parties could find a solution and find an agreement. Some are still ongoing, and litigation is not even looming. Another point in that regard is what's an SME? Germany is maybe one of the centers for SMEs. That's the backbone of our economy, but we have a broad spectrum of SMPs. We have hidden champions with hundreds, if not thousands, of employees and respective turnover. And we have small startups and we have smaller companies. So it's a spectrum. SME is not, doesn't equal SME, which means that that buzzword alone, I think, is bad for that discussion. What do we also see in practice? I mean, Jan and I are representing various clients on the licensor side, on the licensee side in SEP litigation. And we've been doing that since more than 10 years. Extensively, so more than 30, 40, 50 cases a year in Germany, not yet at the UPC. And what's our experience? The instances where litigation actually happens are rare. Many more deals are being signed without any litigation based on friendly, amicable settlement negotiations, so to say, license negotiations, and never make it to court. There's another animal which wasn't touched upon sufficiently in the impact assessment report, and that is patent pools. Avanci, for example, is a role model of a patent pool which was recently created and became very, very successful, particularly their licensing program relating to automotive connectivity. So pool solutions where the market decides, so to say, what the ultimate agreement is in the context of friendly negotiations, where within the pool, often diverging interests must, so to say, be brought together before any license offer can be made, are an important, have an important function on the market to help finding solutions. There are counter arguments, but those are for Jan to make. My personal experience in all of these licensing negotiations is it's always about the price. It's always about the friend royalty. I mean, you have some little issues left and right, but the core of the negotiation is the friend royalty. There we might have need for better transparency. Question is, will that be done by the draft EU regulation? In my view is it won't be done, and I'll comment on that later. When it comes to specialized ADR proceedings, so arbitration, mediation, these types of things, no new ADR center is necessary, not at all, because we have the WIPO, we have a newly established ADR center at the UPC, Unified Patent Court, and we have various other IP-savvy ADR centers around the world. But Jan, you might have a different opinion.
Yes, indeed. At least from my role here today, I think I can agree with some of the points. I also see only a small fraction of negotiation cases where I'm involved, ultimately ending up in litigation. But from my perspective, the question is, why does that happen? And my experience is it not rarely, but rather, at least in my practice, mostly is the case that the SEP owners or pool administrators, if we're talking about licensing pools, they set a rate, and they this rate is sort of set in stone. So you're starting to develop counter arguments why the rate may not be friend. You present that to the SEP owner, and they are of course always nice. They can take that into account, but the price doesn't change. So that is, at least from my perspective, can be a bit frustrating, because even if you may have real, valid arguments why the price may be, I wouldn't even say beyond the friend range, but maybe at the very top of such range, and should maybe or would even in open and transparent negotiations ultimately be lower. But it's basically non-negotiable. It's set, and then maybe one implementer is ultimately drawn into litigation. And once the SEP owner prevails with one patent, then this rate is basically court confirmed. You also know in Germany, our courts, they do not really dive into the calculation. They usually find other ways to consider the implementer to be an unwilling licensee. And there you have it. You have maybe negotiations with 10, 15, 20 implementers. One is taken to court. One is enjoined because of finding of infringement and being found an unwilling licensee. And now you have basically a court-confirmed friend rate, which may not be the one that results in transparent negotiations. So yeah, ultimately it could result, I'm not saying that is always the case, it could result in a rate that may not be actually friend.
I think you have one point, and several others I would see differently in my role. The point where you have a point is that there could be situations, so to say, where someone is forced with the threat of an injunction into a higher royalty. Now the question is there counterpoison to that poison? I'll come to that in a minute. The other point I think you have is that the German courts particularly, and we'll have to see what the UPC does, are maybe too prone to look at the behavior of the parties, because then they don't have to calculate. And then find one of the parties unwilling. There have been cases of unwilling licensors. And my real life experience is that although Christmas is coming, we don't have any angels in this SEP world. I would think, having read and studied and discussed hundreds, maybe even more negotiation histories, that there's always, so to say, bad behavior on both sides. Maybe more or less, maybe one more than the other, but I think it's simply unrealistic to think that there are only angels around, and that therefore, so to say, it's a black and white decision. The one is the devil, the other is the angel, and one should lose. I don't think that's right. So I think that the German courts have to look at pricing in much more detail compared to what they've done in the past, and just do that job, maybe with help, maybe alone. I think there is an increasing interest to do that. I mean, we had our hearings this year and last year where the court was willing to mention a number in closed courtroom only with the consent of the parties, and surprisingly one of the parties didn't accept that, so we didn't hear a number. In one case we did, in fact, so that was nice. Having said that, I think we should bring all of this together, but we shouldn't forget that the hurdle for a price abuse is very, very high under decade-long antitrust law in Germany. And if the offered royalty of a SEP owner is at the top of the friend range, it's friend. And that means it must be paid. Now, obviously, in friendly negotiations, you have certain screws to turn in order to get the price down. And I think it's not appropriate to only look at the forward-looking friend royalty, which is kind of the reg rate you'll find in the internet or in offers, but you also have to look at the past release. And very often on the past release or for past acts of infringement, there is a certain leeway to negotiate, which then ultimately, if taken together, would bring the friend royalty down. And that's what we're seeing basically every day in practice. So that would be my comments on your points.
Yes, I think you can already see this is sort of the core of the discussion. That's why we took some more time maybe on these two slides, because it's basically the question, is this regulation necessary or is it not necessary? And depending on which view you take, it's necessary or not. Not saying that maybe some aspects may be interesting and positive even from your perspective. Also, some aspects may not be necessary or may not be in the current form workable, if you take my position, but that's why we will now take a closer look into what the proposal is, and then maybe look at some of the elements in more detail.
Let me just add one point. If a friend offer of the SEP owner is outright crazy in terms of pricing, in terms of the friend royalty, so a supra friend royalty, it is possible to take this to court. It is possible in the UK, it is also possible in Germany, and it will be possible to some extent at the UPC. So, you know, why don't we see those cases happening more often would be a question from my peer group.
And I would say, well, why is it necessary to push these cases into litigation if we may have a solution that leads to the same result, namely not unfriend terms through a different set of rules, different processes. And I think that's the intention of the regulation. Whether or not it can be achieved, I think depends on the details, and let's dive into those.
So next point, I think we can do rather quickly, the competence center at the EU IPO. The pro is it's an EU institution. The con is it deals with trademarks and doesn't have patent expertise, let alone SEP FRAND expertise. And that competence center will be responsible, according to the draft, to run a EU-wide standard essential patent register, interestingly, including optional patents, and do essentiality checks. Question is, what happens with optional patents when you check essentiality? And most importantly, do a FRAND determination. And for standards where this is requested, do an aggregate royalty determination so that industry knows what the ultimate overall price will be, so that they can price it in their products.
And finally, the idea is to have a compulsory FRAND determination where one or the other side can ask the EU IPO to determine a FRAND rate. There are some obligations, in particular for the SEP owners in this regulation. So there would be a duty to register SEPs, which again has the idea of transparency, duty to register new standards with the option or for the Commission to determine, okay, this standard is problematic, the other one may not be. This could be a point of criticism, and I actually share that. Then an option to indicate a worldwide aggregate royalty. I think we just mentioned that. Here again, an obligation for the SEP owner side. And I think this is also being discussed very controversially. Prior to such registration, there are certain limitations regarding the enforcement of such SEPs.
Mm-hmm.
So this just as an overview of the proposal. Finally, essentiality checks, we already mentioned it. One patent per family, that's the idea, will be checked on essentiality. There can be up to 100 proposals per SEP holder. Of course, SEP holders with very large portfolios, this will be quite some effort. For smaller portfolios, of course, less than that. And FRAND determination, kind of like an arbitration style determination with a non-binding result. But as we just mentioned, mandatory if an SEP owner wants to get an injunction.
It's interesting that you did not mention one point. I expect your clients to chase my clients with 100 proposals each for an essentiality check and make my life cost-wise miserable. So it is possible for the licensee, the potential licensee, to propose patents to be checked for essentiality.
We were going to go into our evaluation of those right now. It's just an overview, but yeah, it's a valid point. Now, this was our overview of the proposal, and now we would like again to ask you, our attendees today, which of these elements of the EU SEP regulation do you consider to be most impactful? Impactful meaning can be both positive or negative, but we would like to know from you. We have basically 4 elements: the SEP register, the essentiality checks, the aggregate royalty determination, and the FRAND determination. And I think we have our view, but we would like to know from you. Again, impactful, it can be positive or negative, but which has sort of the most impact on the practical cases?
While we wait for the results, I just see a question in the chat by Mr. Schnetzer. Why do you measure the question of dysfunctionality with the number of or necessity of litigation? That's one side of the coin. There is a second one, and I think we mentioned that in the beginning, but it's an important one. The whole basis for the EU Commission DG GROW, not COMP, to come up with that proposal is that they are concerned that the licensing market with regard to SEPs is too intransparent and too costly, especially for smaller companies, especially in the IoT space. So one concern is litigation cost, which could be prohibitive, so that smaller companies would just sign any deal. So that's one aspect of this functionality. And the other aspect is also transaction cost in license negotiations, bilateral negotiations with many licensors can be high. You need a licensing department, you might need external counsel. That all takes time, eats up resources, and so on and so forth. So that would be the second aspect of potential dysfunctionality. And I think everybody agrees there are certain dysfunctionalities. The question is, will they be cured with what is on the table?
And I think ultimately we did not measure this dysfunctionality only on the necessity of litigation. I think if you share my point earlier, you can certainly argue that there is a certain dysfunctionality without even having to go into litigation, because this dysfunctionality is shown, is present even without simply looking at litigation cases, because many of these cases may not end up in litigation, but still are not solved in open, transparent, FRAND negotiations.
A third dysfunctionality could be court case law. The focus on behavior of the German courts. Maybe that's dysfunctional. If they looked at the price, as the UK courts do, and the German courts will increasingly do, I heard respective voices, then maybe that dysfunctionality goes.
Right. So we have our results from our second question, and most of our attendees think the FRAND determination has the most impact, closely followed by the aggregate royalty determination, and essentiality checks and SEP register is viewed as less impactful.
I mean, that's the expected result. The aggregate royalty would be certainly nice to have, because then you can do proper pricing when it comes to selling products or services using the standards at issue. FRAND determination is, as I said before, front and center, and the aggregate royalty is just a part of that. So that this wasn't very surprising, I think. Right. So let's focus on those points most.
Definitely. So we have, of course, slides for all these four elements, but indeed, maybe we can focus on these 2 points. On competence, Tilman, I think we already mentioned sort of the concerns that may be voiced regarding the competence of the EU IPO. You mentioned it.
I don't think it's EU IPO related. It's more a matter of the concrete persons who are actually going to do the job. That means determine the aggregate royalty and determine the FRAND rate. You need patent law experience. You need antitrust law experience. You need technical experience, and you need economic experience. So someone with all these, factors in his person is a rare animal in the zoo. And those persons are typically highly paid, as we know ourselves, so to say. Question is, will it be possible to find personnel, no matter whether it would be EU IPO or EPO or what have you, will it be possible to find personnel that does the job in a proper, harmonized, undysfunctional way? I heard rumors that the payment for a FRAND determination for the conciliate is doing it would be 5,000 euros. That's simply ridiculous. Nobody will do it for that money. So higher payments would definitely be necessary. Otherwise, those persons who would run into conflicts if they're in private practice, obviously, would decide not to do the job. I would not do it for 5,000 euros, period.
Right. I agree. I think indeed, what I have read, a lot of criticism or concerns are actually also about the EU IPO as an institution, whether this is the right one. I think, at least from my perspective, nobody would be against having some other institution being sort of the body where this SEP regulation is implemented. But still, maybe the question to our audience as well.
I think we should skip that, Paul. I mean,
yeah, whether
it's not really helpful.
It's not really.
Let's move on to the important topics.
Let's skip that. The SEP register, I think, also not the most important point. We mentioned already sort of the key points. I think the upside could be when we're talking about chances, if you have such a register. In my experience, whenever licensing negotiations around SEP portfolios start, one of the first questions is always, do you have claim charts? Can you prove that your patents are actually essential? Because we know about over-declarations. And if you really look at the patents, then a portfolio of a couple of thousand declared SEPs suddenly becomes only, I don't know, a couple of hundred. And if you want to do a top-down approach, maybe the royalty also can decrease. So the idea, I think, from the regulation would be to do this this job or this task before negotiations start. So both sides, SEP owner and implementer, already have that out of the way. They know, okay, we have a certain number of tested SEPs, and now we focus on the number on the pricing for those SEPs.
I fully agree that if we were in an ideal world and if we had an ideal SEP register, that then it would be very helpful. Now that's not going to happen. That's not going to happen, and that's the problem. And my main concern here is that this will be taken as the basis for the aggregate royalty and the FRAND determination. Why won't it happen? One patent per family. So you might do strategies. Why not use a clearly, so to say, non-SEP to be checked? And then you have a free ticket on the rest of the family to assert them in court immediately without having to going through any FRAND determination. Why not, slice up portfolios to play a bit with the families? Why not change a comma? So the divisional game will become much more important here. And that means patenting costs will become much more important. Second concern, if validity is not checked, the factual basis of that register will simply be bogus. Most of the SEPs die in practice. Only a small fraction survives if they are tested in court. And for the ideal world, that must be taken into account. So how can you do that if you only look, so to say, at infringement, which is essentiality, but if you don't look at validity, if that's not allowed, so to say. And that error, so to say, will then be a consequential error in whatever comes afterwards on that factual basis. And that will be a main reason why I don't think that courts will, highly appreciate the non-binding results which come out later. Third, smaller points, utility models not covered. I would simply branch off from each product or system claim, which is then essentially a utility model, and assert it if my time window is still sufficient to do it. Yeah, if it was ideal, it would be ideal, but it's not.
Yeah, I mean, you have a couple of very valid points. The idea behind it is certainly helpful. It would require, I think, a lot of effort. And I mentioned this at the very beginning regarding transaction costs. Even though I take the view that today that this regulation can be helpful and maybe even necessary, at the same time, I was wondering when I prepared for today, does it really drive down transaction costs? Because I'm guessing you're doing a lot of work for negotiations which may have never presented these questions, which would have been resolved without any of these questions. And so it appears to be, or at least I see the risk of a lot of overhead costs, which may have never been necessary without the essentiality checks.
And let me just echo that point. If you look at the big SEP owners, the Nokias, the Ericssons, the Qualcomms, you name them, how likely is it that there is a patent which is not essential, which is essential, that means infringed, valid, and still alive, so to say? There will always be one, there will always be several. So that transparency to the market, that means to the potential licensee side, will not be overly helpful because they can take for granted, and that means save the respective costs to analyze all of that they will be infringing a valid patent, likely several. And the question then is simply what to pay for that, and not be distracted by, you know, technical analysis and all that stuff.
Right. And I think final point, what's of course always the question, do both sides accept the result of such a check, because it's non-binding, so there is still the possibility that an implementer may still challenge essentiality in front of a court if it comes to litigation. So again, ideally, it would be a very sound check. It would be accepted by everybody and therefore prevent litigation, encourage, facilitate negotiations. But indeed, there are question marks, I think.
I think that one we should do.
I think that one we should do. So question again to our audience. Do you think essentiality checks should be done for SEPs? And do you think this would be helpful if it's done? Let's assume it's done correctly and at least, yeah, not with too many question marks.
While you do the voting, there's a question from Jean-Marie Le Yaonac, or so, sorry if I butchered the name, and that goes, do we know the standards which will be considered by the EU IPO? Not yet. There will be a discussion whether for certain standards there are already market established royalties so that no further work is necessary. And for certain standards, that's necessary. As the Commission has focused on the IoT space, I think the cellular standards are particularly important for those use cases. Will be different with smartphones and things like that. Audio compression, video compression could be, if you think along the lines of entertainment products, could be very relevant standards. But there is no insight yet whether it's going to be many or whether it's going to be just a few. Having said that, you know, doing a regulation which is directly binding in the member states for just a few standards would be fighting a mouse with an elephant.
All right, we have the results, and clear majority, almost 80%, thinks that essentiality checks should be done. Of course, maybe influenced by the assumption that they are done very carefully.
And I can understand that if you can save the world, why don't you at least save half of the world? So one side of the coin you already have. My concern is that this will be taken as a basis for the further determinations and will play an important role. And if that's the case, then we have a problem.
Maybe one other question in that regard, Tilman. I think it was or is discussed whether these essentiality checks can maybe be implemented on the standard setting organization side. So I think if you consider essentiality checks to be helpful, but the regulation as such to be maybe critical or yeah, with room for improvement, What do you think? Would it be an option to simply carve out this essentiality check and do it somewhere else, for example, within the standard setting organizations?
Yeah, I mean, that would be a natural place. But again, I don't care about the institution who actually does it. I care about the individuals who actually do it. And if they are well paid and properly trained, then we're going to get good results. And if they aren't, we won't.
Right. All right, let's go to the next point, next element, which is the aggregate royalty. So here, I think the idea is that setting such an aggregate royalty, determining it once, simply provides security for the implementers. They know, what sort of the royalty burden on a product is. It prevents that each SEP owner, which I've seen in practice, each SEP owner argues with their share and maybe ignores what else is out there. And if you look at each one individually, you think, well, yeah, maybe friend is not, you can afford this as the implementer, but maybe lose focus on, well, if everybody charges that, then we're looking at a burden of royalties that may be problematic. So I think that is the idea behind the aggregate royalty. Again, I think certain concerns about that as well.
Mm-hmm. So one concern I have, and I'm quickly switching roles, so I'm you now, but just for a minute. This is going to be a show which will be run by the SEP owners, and the implementers don't have a real say. And depending on how much leeway there is to put pressure on the conciliators to, use high aggregate royalties, we might see something which could be very much against the interests of the licensees. So I don't think that's equality of arms on that point, which is why it's not good in any event. Now, having said that, what will we be able to learn from that? Again, it depends on the persons. Also, it's very difficult to come up with an aggregate royalty because that might well be different for different use cases. And a flat aggregate royalty for a certain standard for all sorts of use cases is probably problematic because it's flat and not specific and individual. That's one thing. The other thing is that there is a certain chance that although the focus is on the SEP owner side, that we will still get meaningful results because not a SEP owner doesn't equal another SEP owner. We have folks from Yahweh on the line, at least they registered for the event. And they will know best, so to say, how it is to have been a net licensee and now transforming into a net licensor, but still being a licensee as well. Ericsson Nokia are also licensees. Question is to which extent. But that's for another day to be discussed. So there are diverging interests even within the group of the various SEP owners, and that will hopefully lead to averaged reasonable results. And I would just like to take up one question which was raised by Mr. Galli. How do you reach a consensus over an aggregate royalty among SEP holders with different business models, NPEs versus PEs pools? That's exactly the point. And I'm a big believer in swarm intelligence. It will be no magic. It will simply be negotiation among them. Like we know it from pools, there is no magic. It's bringing all the interests together and come up with something with which everybody can live. Knowing that it's no magic, question is whether transparency will change those dynamics.
And whether it drives down transaction costs, because that is, again, a lot of work, a lot of effort until this aggregate royalty is determined. So that could also be a concern.
Next poll.
We want to know from you. Do you think that determination of an aggregate royalty can facilitate SEP license negotiations? All right, we almost have all votes in, and we have a clear winner here. So in our audience today, over 80% think that such an aggregate royalty can indeed facilitate SEP license negotiations.
And again, that's not surprising because that will show you ultimately the market price you have to pay in total. And that's very helpful for business forecasts, etc.
Whether or not it's an actual market price, that's the big question, of course, and yeah, the basis for the concerns. Brings us to our last element, the friend determination, which was also the most controversial or impactful from our audience. So I think, yeah, what's the chance behind that? The chances is, of course, to prevent unilateral enforcement of non-friend rates, because if you think as an implementer, whatever is requested from you is not friend, you can simply request the determination of the real friend rate. But I think you have some concerns, Tilman.
Maybe you go to the next slide. Yes, I have concerns, and I must say it's nearly ironic. The whole purpose of the friend determination is to provide transparency and to avoid litigation and help parties to come to out-of-court deals. Now the contrary will happen, and I'm absolutely certain by that. In that regard. So what's going to happen? We're going to see litigation tactics employed within the 9 months, and in fact it's 12 months if you calculate everything together. Friend determination. A smart SEP owner will take on an easy target and just flood that target with tons of surveys, expert reports, license agreements, and all that. To then hope that the target cannot afford or is at least not willing to defend properly within that friend determination, and that then a highly inflated friend determination is the result of that exercise. So I think I think potential licensees should look at that issue very seriously and consider whether it really is in their favor. Given that the persons who are going to do the job are not known, given that the persons who are going to do the job are intended to be not overly well paid, that means they're open to pressure. Another point here is that the friend determination is obligatory before you can actually file litigation. That means effectively litigation is delayed by a year. And that means that effectively the lifetime of a patent is reduced by 1 year because the patent, at least in continental Europe, is the injunction. Damages are interesting, but not as relevant. At the inaugurational speech of the Unified Patent Court, Chief Judge Grabinski said that this mechanism as drafted would contravene the Charter of Fundamental Rights, proper access to justice, proper property rights, so to say. And recently, Justice Robin Jacob, ex-Justice Robin Jacob, he's now retired, and a university professor in London from UK, former barrister and high-end UK judge, has written a letter which was created at the Venice Conference, where the European patent judges regularly meet, and stated in that letter that it was the unanimous opinion of all those judges present there, that were probably 20 as usual, a bit more, a bit less, something like that, that there is an issue with the Charter. And they proposed, why not do the friend determination in parallel to litigation? And even if it would be mandatory to only go to court after it's been done, I think smart SEP owners will simply file a litigation when the friend determination starts, will ask the court to schedule a hearing date until after the friend determination is done, and then get the injunction a week after or 2 weeks after, so to say, if the friend determination is in their favor. And it's non-binding anyway, so the question remains, what will the judges, that will be my question to you, make with that? The other point in that context is preliminary injunctions could come up. So far, that's pretty much unheard of to grant a PI based on a SEP. However, if judges don't like that, what's happening there, they will find ways to help SEP owners. And one way could be to await the friend determination. Then you file a request next day, and 3 days later, you get your PI. Whether that's really in the interest of licensees, I don't know. And Jan, what's your view?
So I have problems arguing with the legal assessment because I do think these concerns have merits. Regarding this sort of commercial arguments, yeah, they are certainly valid. Of course, from an implementer perspective, at least, yeah, I've seen the argument, why is an injunction even necessary if you're obligated to grant a license anyway, and we have a mechanism where at the end there is a friend rate determined, why need that threat of an injunction? May not be necessary, maybe even yeah, counter objective. So I do see some yeah, some
I can tell you
upsides.
why the injunction is necessary. If you wouldn't have an injunction, nobody would sign a deal, because the worst that could happen to you is that you pay what you would have to pay anyway, without any additional risk. That means that would be the perfect holdout situation, and the SEP owner would bear the insolvency risk of the licensee during all that period until a deal is actually made.
Fair points. I mean, and brings me to your earlier question about how binding is it. Certainly, if the friend determination is non-binding, then I agree with you. I mean, then you can basically sit it out and still do nothing. So maybe you need some sort of combination of the two. And if there is a determined friend rate, then have the obligation for the implementer to accept this rate then.
So why not? Sorry, I have to say it at this point, although we have this poll coming up, but it's near and dear to my heart. Why not coming up with a mechanism, an institution that produces reliable binding results? And who should do that? Arbitrators could do it who have experience, judges could do it. Arbitration is probably the best way to do it. Why not implement something? But this is wishy-washy. I mean, in Germany, we have a saying, wash me without making me wet. Non-binding, no appeals, no judges, no arbitrators.
Yeah, and I struggle arguing with that point as well, because we know our German judges, and we know that they want to have control over their case, and I have my doubts that German judges will really consider such a determination binding. Not only the friend determination, also the essentiality check, everything we discussed earlier. If that's non-binding, then yeah, we may not have gained anything.
Plus, we're going to see disharmonized results, which will then make it to court into litigation, because the conciliators have no guidance whatsoever about the methodology, how to determine the friend rate. That means some will play with comparable licenses, others will play with top-down approach, others will do a mix. Some will be more SEP owner friendly, some will be more licensee friendly, all these things. So I'm really concerned that we're going to see arbitrary results which don't fit to each other, and to then use those results as a safe harbor in litigation is a very risky game.
And as you mentioned, it can be for the benefit or to the detriment of implementers. So it's not a given that it leads to lower rates than they currently would have resulted. So our final question to our audience, do you think a friend determination process can reduce the disputes between SEP owners and implementers?
And while you vote, because we won't be able to make that slide anymore, I'll quickly cover the questions which we received in advance or prior to this webinar. Thank you for those. The first is, why should any friend condition be confidential? if we need full transparency, because that's also in the draft. And that's the best question, I must say, that could possibly be asked. If you want to do it transparent, then do it transparent. That means fully for both sides. Both sides should be obliged to put the agreements on the table, because there won't be, in the majority of cases, so to say, real comparables which fit one-to-one on the same licensee, same business model, etc. But they can all be data points which could be taken together, even if they relate to other portfolios, to come up with something which is kind of the common denominator. Second question is, how will the courts deal with the aggregate global royalty under Article 18? As we said, I'm concerned that the judges won't care much anyway about whatever comes out of the EU IPO, whether that's the aggregate royalty or the FRAND determination. Next question is, how do you see the role of the EU IPO? I think we covered that already. And then, do you think the focus will continue to be top-down rather than comparable licenses? At least from a German perspective, comparable licenses are much more important than a top-down approach. Having said that, if you look at the UK judgments, there is no particular magic in it. It's a lot of patent counting and Solomonic, so to say, views taken. And that's one of the key concerns I think both of us have. If you don't have guidance on the methodology, the results might well be arbitrary and change a lot from conciliator to conciliator.
Those were the questions we received in advance. If there are still questions, we have 2-3 minutes. You can type them in. Until then, Tilman, maybe a quick outlook.
Yeah.
We have now this draft. It's being discussed very controversially. I think they received some 800 amendments, something like that.
Many thousand comments, right, and lots of amendments, I think even more than 1,000, I'm not sure. And we have European elections coming up in June next year. And I must say, I'd be surprised if the draft makes it in time through the trilogue, so gets the vote in Parliament, gets the Council's agreement, and then makes it into law. I'd even be surprised that the Parliament would actually vote on it before June 2024. And if that doesn't happen, then everything could be, put way down the priority list, because we might then have new politicians with new fishing rights to be traded. We have macroeconomic issues with wars and all that. So there's a lot of bigger fish to fry. And I don't think it's going to be possible to digest all of these proposed amendments and digest all of these comments, take them, implement them, so to say, in the draft, and come up with something which is more than a strange mosaic with lots of legislative faults in it. Even spelling is an issue, I must say. I don't think it's going to come anytime soon, but you never know. There are political powers. There's a lot of lobbying going on, and we'll know in June. I heard that if the Parliament hasn't prepared everything for the vote in February, then it might well become too late. And preparing for the vote means having digested all the comments and amendments and provided something new, so to say, to the public. That's not the speed in which politicians typically work, I would say.
That's true. With that said, we did not receive any further questions. We do owe you, I think, the results from our last poll. And again, almost 80% think that a FRAND determination process can reduce the disputes. Again, I think not surprising. If it's done correctly, if it's done right, then it could help. I think the question is, how can you do it right? And I think at least based on this draft, there are a lot of concerns.
And we hope it was entertaining and also informative. If you have any questions, share them with us. We're happy to respond also after this webinar. Thank you very much for your attention, and hope to see you next time when we do another edition of this.
Thank you, and have a good day.